120 words per minute for 10 minutes. 5 seconds more. Start. This pro bono publico petition filed by the petitioner seeks for the following reliefs: issue a writ of mandamus or any other appropriate writ, order or direction to respondent number 1 to forthwith rehabilitate all of the families in the list of 94 that have documents establishing residency prior to 31st December 1998, including the 68 the respondent number 1 has already agreed to process such documents. Rehabilitation should include the allocation of plots along with ensuring that all services and community infrastructure is available. Issue a writ of mandamus or any other appropriate writ, order or direction to respondent number 1 to forthwith decide by way of a reasoned order which is communicated to the Juggi dweller in writing and a receipt thereof taken with copies thereof sent to the petitioner number 1, and in accordance with the criteria set out in the policy, the suggested protocol, the rehabilitation eligibility cases of all the other 650 Juggi dwellers mentioned in various correspondence between the petitioner and respondent who were evicted and who now live near Bhavana, and further to rehabilitate all these applicants by allocating plots to those found eligible within 6 months from today. Pass an order directing an investigation into past improper actions during the earlier evictions and subsequent relocation denials, including allegations of corruption, the repeated and deliberate refusal to grant residents their proper relocation allotments, and the recent demolition of residents. Pass an order directing respondent to complete the enquiry into allegations of corruption with respect to the 54 complaints filed and complete the investigation within 3 months and punish in accordance with law. An order directing the respondents to follow from now on the criteria laid down and the suggested protocol for rehabilitation, eviction or demolition in the case of all Juggi dwellers, particularly with respect to but not restricted to the following: accept any bona fide form of evidence of residence when making residence-based eligibility determinations. Refrain from evicting or demolishing houses until all rehabilitation determinations have been properly made and eligible residents have been properly relocated. This should include allowing the residents to present all relevant information and have that information properly heard in order to contest an initial determination of ineligibility. Explain what public interest they believe necessitates evicting these families from the homes they have been living and allowing the residents a proper venue to challenge the factual and logical basis for this determination before the eviction is carried out. Refrain from any future evictions or demolitions that are not accompanied with a proper order posted at the relevant site authorizing the eviction or demolition, which includes an affidavit that all proper procedures have been followed. Such an order should include penalties for any officer that authorizes such an eviction or demolition without following all proper procedures. Ensure that all basic services including water, power, sanitation, education and health services are available at relocation sites prior to evictions. Ensure that relocation sites are as close to the original sites as possible and that communities are not split up as part of relocations to minimize the disruption of social networks and employment. Pass an order directing respondent number 2 to conduct a door-to-door survey of the residents without allotments following the above mentioned procedural requirements listed listed in the orders to ensure that all other eligible residents are included. The grievance of the petitioner appears to be that for several years as many as 94 families whose names are shown in the list annexed with the petition were residing unauthorized along with a large number of families. As these families were sought to be evicted, they wanted rehabilitation. Since such rehabilitation was not made in respect of 94 families, the petitioner seeks for a direction in respect of prayer to rehabilitate all of the 94 families in the list who have produced the documents to establish residency prior to 31st December 1998. Learned counsel appearing for the respondent has submitted that in fact in the places in question 1435 squatters have been identified and they have been rehabilitated. However, 94 squatters were found ineligible for such rehabilitation. Thereafter, the matter was again reconsidered at the level of Lieutenant Governor and further 20 squatters were found eligible, leaving 74 ineligible. As far as the relief for the remaining 74 families are concerned, it is not for this court to go into the details as to the eligibility in these proceedings, as it would be only in the realm of the authorities to find out their eligibility on the basis of documents. Though the respondent has taken a stand that all eligible squatters have been already rehabilitated and the 74 families whose names are shown in the list are found ineligible, we are of the considered view that in view of their grievance that they had been living there for quite number of years, their grievance may be addressed by the respondents by once again making such verification. In view of the above, as far as prayer 1 is concerned, we direct the respondent to revisit the claim of the 74 families by making one more exercise for verification, and if any family is found eligible, they can consider them for rehabilitation as per the policy in vogue. As far as prayer 2 for rehabilitation of 650 Juggi dwellers are concerned, for want of any details, we are not inclined to issue any direction except again permitting the petitioner to furnish the details of those Juggi dwellers before the respondent for consideration. In the event such request is made, the respondent has to consider it by making necessary inspection and then decide as to whether any of the 650 Juggi dwellers are eligible for rehabilitation as per the policy in vogue. As far as the decision in respect of 74 families is concerned, the respondent is directed to take such decision within a period of 6 weeks. As far as direction relating to 650 Juggi dwellers are concerned, the same shall be complied with within 3 months from the date of the receipt of the request, with details from the petitioner Juggi dwellers. With the above direction, the petition is disposed of. During the pendency of the writ petition, the petitioner has also taken out an application wherein the petitioner has made a grievance that during the pendency of the writ petition, a fire broke out in the slum cluster on 13th April 2013 around 1:30 am, and and almost 800 slums were burnt to ashes in not less than 30 minutes. In the said fire, 4 children and 1 woman lost their lives, leaving several injured. Hence, the petitioner seeks for a direction to provide food, water, and medical help to the said 800 slum dwellers. Insofar as the said relief is concerned, the state is obliged to look into the said grievance and provide water and medical assistance and to some extent food as well to those who suffered due to fire. We therefore direct the government to take immediate steps to provide the above facilities to the said slum dwellers without any further loss of time. This direction would be as an interim arrangement, as the victims should not be made to suffer. However, we make it clear that this direction shall not be construed as one of recognizing the eligibility of those persons for rehabilitation as sought for in the writ petition. With the above direction, this application is also disposed of.